AI and disclosure management. Hello, and welcome to this episode of the 39 Essex Chambers AI and the Law podcast. I'm Katherine Apps KC. In this episode, our guest is Tom Whittaker, who's the Director and Solicitor Advocate and the Head of AI Advisory at law firm Burges Salmon. In that role, Tom advises on regulatory risk, governance, and complex investigations and inquiries. Tom is also on the AI committee of the Society for Computers and the Law. Welcome, Tom.
Hi, Catherine. Great to be here.
Well, thank you very much for joining us. Now, in our last episode, we discussed AI in the courts. Now, in this episode, we're going to take a rather deeper look at AI in the context of disclosure management and issues which arise when litigation requires disclosure of and evidence relating to large computerized systems. But first, Tom, you're obviously very interested in artificial intelligence. How did you find yourself specializing in this area?
It started early in my career as a litigator, so I was faced with significant volumes of documents and manual processes in disclosure exercises, and when we were trying to get to the heart of the evidence. It was the sense that there must be a more effective way that led me to specialising in the law, technology and practice of disclosure, and then gaining experience of that across a variety of types of cases over the years.
Now, one of the most expensive and time-consuming issues in commercial litigation in particular is the process of reviewing and listing which documents held by each party are potentially relevant to the particular pleaded dispute, and then redacting any passages within each of those documents that are protected from disclosure because, for instance, they contain legal advice or material that is privileged. Now, this can be particularly significant if the relevant period of the dispute covers a substantial period of time. Now, as you say, for many years, lawyers have just hoped that there is something that can help them with this enormously time-consuming task. Tom, just before we delve into what AI can do, can you just outline what the court expects the disclosure process to involve in England and Wales courts?
So first, it depends on the courts and the procedural rules. But generally speaking, these offer a range of models, ranging from disclosure of only key documents to disclosure of categories of documents, to reasonable and proportionate searches, and ultimately all the way through to a no stone unturned and train of inquiry type set of searches. And in public sector disputes, there may also be a duty of candour upon the public body or individuals also. Now, these often rely on a test of relevance. Broadly, whether a document is relevant to the issues in dispute, undermines the disclosing party's case, or supports the receiving party's case. Practically, most require the parties to identify, preserve, collect, search, review, and produce documents. Documents are usually then disclosed in a list, along with their metadata, and produced in native form, unless, as you say, they're redacted or withheld, for example, because they're privileged. Often the parties have to cooperate about their respective approaches and explain what they propose to do, and then ultimately what they have done, to each other and to the court. There are common themes through most types of disclosure exercises, and in my experience, also in other types of work requiring the collection and handling of data. But despite those similarities, there are differences depending on the procedural requirements in each. Consequently, how you go about the exercises and the dynamics in each exercise can differ, and there may be some difficult points to consider when there are multiple proceedings in place, each with different disclosure regimes.
Well, indeed, it can get extremely complicated. But what do you think that AI can do in this context to make things simpler, cheaper, and better?
So I think AI in this context, in terms of it being an umbrella term for various technologies that give us multiple tools to use. So AI won't be a silver bullet. Each tool may be useful as part of a specific stage in the multi-stage process that I explained a moment ago. But given the challenges we've described so far, they can have a potentially significant and useful impact. So a few examples, but out of many that there may be. So one is classification. So, for example, classifying whether a document is relevant or not, or perhaps classifying the percentage of similarity between that document and the relevance criteria, or other documents that have been coded in a particular way. Some may use this to assist a reviewer's analysis, or potentially you can go further and replace a first level of review where you're trying to whittle down the documents so that a lawyer or the next stage can get to see the documents identified as potentially relevant sooner. Now, another example could be categorization, helping to put documents into logical groups. That can make more efficient for humans to review as the individual is reviewing similar types of documents. Or perhaps it can produce a seed set of conceptually similar documents so that another AI tool can then train based on those. A third example would be text analysis. For example, to identify text and images, such as scans, where we've traditionally used a method called optical character recognition, or OCR. However, that method is imperfect. So I've seen examples of where OCR has been used in addition to GenAI to improve the extraction of text and tidy it up afterwards so that a human can understand it, and ultimately it can be searched and used as part of other search methods and AI tools. The final one that I'd mention by way of example is that in the near future, I'd expect agentic AI to play more of a role. So, agentic AI is where a system can orchestrate multiple tasks to achieve a goal with minimal or potentially no human instruction. We already have systems that, subject to party and court consent, can compare live feeds of hearings against evidence to identify inconsistencies against that evidence. So, in my view, it's not much of a jump to imagine them using agentic AI to triage inconsistencies and draft questions for counsel so that counsel can then put those questions to a witness faster and more efficiently than otherwise. But one point I'd finish on with all of those examples is that they can be used in combination with each other and with other processes too.
Well, indeed. So the issue of privilege, that can be particularly difficult, can't it? Because I think in the early stages of some of this technology, there were sort of searches that were supposed to help with privilege, which essentially looked for the name of the lawyer within a certain number of words of the word advice or advisory or other roots of those words. And there was a relatively recent case in the courts of England and Wales in the Technology and Construction Court where a law firm, not your law firm, I should say, inadvertently disclosed over 4,000 privileged or partially privileged documents in the context of a claim against the Gambling Commission concerned with the procurement of the fourth national lottery competition. And I'm certainly not saying that that particular issue of using automation happened in that case, but it was a very large number of inadvertently disclosed documents. Is there anything that could be done within the context of an e-disclosure platform that might have reduced the risk of such a large-scale disclosure of otherwise protected documents?
It's difficult to know exactly what happened in that case, but it does illustrate some of the risks and potential consequences in disclosure exercises. And as you mentioned, there was a large number of documents inadvertently disclosed. And in terms of a bigger context, which is that the disclosure exercise included a manual review of over 330,000 documents by over 60 first and second tier reviewers. So it's certainly a significant exercise. And I think what we're seeing more so with various types of litigation, but also other e-discovery exercises, is that you can have very significant exercises of this sort. So the risk is one that was likely to remain present. So one of the issues that was alluded to in the judgment in that matter was about near duplicate documents. The judgment noted that the disclosing party had a system which created different versions of documents when minor amendments were made, meaning that the disclosing party had multiple similar but not identical documents. So in my experience, near duplicate documents, or indeed similar content that appears in multiple documents, can increase the risk of inconsistent approaches between those near duplicate documents or content. So in the privileged context, you may have two documents which are near identical and they both contain privileged content, or you may find that privileged content appears in a wide range of documents. For example, the original advice, then an email, maybe then in a Teams chat, and so on. And so they could appear in multiple places. Now, there are technological methods to identify near duplicates or near duplicate content. So, for example, what's called textual near duplicate identification. And then also there's technology-assisted review, and there are Gen AI approaches which look for similar concepts across documents. There are then additionally separate tools which then redact repeated content. Now, traditionally, they have been used for identifying personally identifiable information and then redacting that, such as sort codes or people's addresses. However, what I would say for the technology that is trying to identify that content and redact it is that no technological solution is perfect, and certainly not on its own. And the issue arises partly because of the way a party's systems are set up and how the data is collected, processed, and analysed before review. So we should be mindful in these circumstances of what we can do to identify and mitigate risks in advance of review, and not simply jump to the technological solution at the point of review later.
Well, exactly, because they really can be devil in the detail, can't they? I remember doing a disclosure review once. It was obviously advice in the documents, but there's a question as to who the advice came from. Was it actually the lawyer's advice then being reproduced by others, or was it advice from people who were not lawyers, who were extremely skilled and experienced in the particular dispute, but were giving advice which would not be protected by legal advice privilege? The content of that advice might have been absolutely identical, but the question of the source was absolutely key for deciphering whether it was legally privileged or not. Just sort of teasing out a few of the issues, though, from what you're discussing. There can be absolutely mind-bogglingly large volumes of material in particularly complex cases, can't there? Is there anything that you've sort of picked up in terms of your practice, in terms of managing quite such large volumes of material and how that tends to work out from what you're seeing?
So one of the things that I will always go back to is the use of the Electronic Discovery Reference Model Framework, which is an international standard, largely out of the US, but adopted globally, I found in my experience, as a way of viewing disclosure holistically. So moving through those steps that I mentioned earlier about identification, preservation, collection, analysis, review, and production, because that then helps you to do a number of things. First, it helps you work out how you can tailor your disclosure process for the obligations and objectives that your client has. So, for example, the legal objectives and obligations that they're under due to court order or procedural requirements, for example. It also then helps you identify at what stage you're at with the different document sets and your different workflows, so that you can ultimately tailor each different stage to the subsequent stages. But also when, for example, you're using an AI tool, as I mentioned earlier, at a particular later stage, such as the review stage, you have that possibility in mind at an earlier stage, so that you seek to collect documents and preserve them with information and structure that will ultimately make the review more efficient with that tool. And then ultimately, depending on the workflow and on the need, then we have a variety of different tools available, whether that is through the document review platforms, using AI to classify documents for potential relevance, to classify them based on conceptual similarity, so that we can then look for similar documents and check for consistent or potentially inconsistent approaches between them, or to be able to draw out other information that we may find useful. So, for example, entity analysis, or to build dramatis personae to help us build up that picture of who was involved. So going to your point earlier, for example, about trying to understand who were the lawyers or who were the individuals, and then in what context they may have been sending or sharing information as well. But really, there's so many different scenarios. What it means is that you need to go back to that core framework, but also be aware of the types of tools and processes that you have available to help you achieve your objectives.
Well, there's a kind of access to justice point in there as well, isn't there? Because actually sifting enormous quantities of disclosure that the other side has made can itself be hugely time consuming. And parties have to consider what actually do they have by way of their own funding to be able to find the things that, the needles in the haystack, as it were, within the amount of information that's been disclosed to them.
I would agree with that, that the volume of data that is being collected and ultimately being produced does mean that the receiving party may have to review a significant volume of documents, and they need to factor that in to their costs and to the timings of the case as well. And that can be a particular challenge when there are limitation periods which arise from knowledge of certain documents or information. And so when a party receives a significant volume of documents, they need to be aware that time may be ticking. And so they need to identify potentially relevant documents, escalate it appropriately, and then decide whether or not they need to do something, for example, amend particulars of claim or their position.
Touching on a second aspect from your discussion of that particular case, one of the key issues, particularly with any large disclosure exercise, is ensuring that the actual process of review and disclosure itself can be fully, clearly, comprehensively explained to a judge who might not necessarily have a technical background themselves, or where technology has moved on from when they were in practice themselves. What are the practical challenges you think to this? And also, are there any solutions to being able to explain the process?
Certainly. So there's 2 points for context, I think, first of all. One is, at what point is a judge likely to engage with the disclosure process and what's required? And the initial stages is likely to be at the case management conference, which is after when pleadings have been exchanged and where there may have been some initial or pre-action disclosure. And then second of all, it may be at a later stage. So for example, if the parties seek a disclosure guidance hearing, or if there becomes an issue within disclosure and the proceedings for which a specific disclosure hearing needs to be heard. The second contextual point is, well, what information is available to the judges at those points? So let's take, for example, at the case management conference, the judge is likely to have before them the pleadings, the initial correspondence. So that means they should understand what the case is about. Second, what they're likely to have is some of the outputs from some of the disclosure procedural requirements, which are often to be documents where a party explains what it is proposing to do and what data sources it has, and ultimately what things it can't do because it is either not feasible or it considers to be not reasonable or not proportionate. And so in those contexts, the judges are likely to already have a useful volume of material against which to make decisions. Then ultimately, the question about explainability comes down to what is it that needs to be explained. And so I'll just turn to a few different points. First, those explanations may be possible by way of logic. So, for example, if we're talking about keywords or custodians or date ranges or something along those lines, it may be possible to determine by logic whether or not what's being proposed is appropriate. So you may be able to see that keywords appear in core relevant documents, or you know that a custodian was involved with some of the relevant issues. However, we know that keywords are a useful but not a perfect tool. They may miss relevant documents, and they may be over-inclusive with irrelevant documents. And that's because at the point when you're trying to determine your approach to searches, you ultimately have an imperfect insight into the data universe. And consequently, there may be types of documents, types of communications, or expressions used that you're simply not aware of early on. The second point that I'd make is that I've heard some judges say that they expect parties to have collected data and run tests of proposed search terms in advance of a court hearing on disclosure. So that would mean the parties can explain what would happen if one set of search terms was used instead of another, for example, in terms of the number of documents returned and consequently the potential time and cost that may be required for the disclosure exercise. However, there may be reasons why parties don't do this. So, for example, there may be issues which are not agreed between the parties, and the parties believe that it would not be appropriate to collect and search documents in advance of those differences being resolved. So it's not uncommon to see that the court may make an order for the parties to take more time to try and agree disclosure parameters, and failing that, return to the court. My third observation is that there will then be some things that we are potentially seeking to do within disclosure exercises, which are highly technical and maybe more challenging to explain. However, I do think there will be some methods to be considered. So an example could be using generative AI to help whittle down documents for review. So, for example, using various prompts to help identify documents which are likely relevant against the issues in dispute. So let's say we prompt the AI model, and then it returns potentially relevant documents. How does one then explain why one prompt is preferable to another? Should we add an additional phrase? Should we remove certain phrases? And that's particularly important when we're trying to consider whether proposed amendments by the other side are appropriate. Now, it may not be possible to explain how the AI system is working or how the foundation model is working, but there's at least two things that you can see and then seek to explain. So first of it, you can see on the face of the prompt whether it seems logical against its purpose. So in effect, similar to what I was saying about logically considering keywords and search parameters. Second, it is possible to use Gen AI alongside other and well-known technologies, such as technology-assisted review. So that may mean that the parties have available at their disposal established statistical methods to calculate the probability of there being relevant documents in the unreviewed population. And that goes back to the point that parties are often undertaking a reasonable and proportionate search rather than trying to find every relevant document. And then the third observation is that it may be possible to test different prompts. However, that would then incur cost of running those prompts and then the time of reviewing the outputs from those. And so it may not always be appropriate to do, but it may be some way of trying to understand whether one prompt is appropriate or not.
It's also particularly important to be aware of when procuring disclosure software as to how exactly it's proposed that this is to work, because there can sometimes with generative AI be this reproducibility problem. One of the advantages of generative AI is that it can be hyper-personalized to the particular user. And obviously in the disclosure context, hyper-personalization and lack of reproducibility of outputs between different users would be a very major issue in the context of commercial litigation. Now, Tom, this is all very complicated, but it becomes even more complicated, doesn't it, where the legal dispute itself is about a large computer system and its operation, doesn't it? Now, I know you've got practical experience in this particular area. Can you just explain, ideally in terms that our listeners will understand, as to what exactly those complicated issues are involving disputes about the operation of large computer systems?
Certainly. So there's potentially multiple issues, so I'll just pick out a few. So first, what system or systems are the subject of the dispute? It is possible that when one thinks of a system, what one is actually dealing with is a series of different and dynamic systems, each with different technical issues and limitations. So we have to be very specific about what is it we're specifically focused on and what is the subject of the dispute. Further, what we may be concerned with is not simply the computer system itself, but how humans and organizations have designed, procured, and interacted with those systems. Question whether there is anyone within the organization who has both broad and deep knowledge of the multiple systems in play. If one has to speak with multiple people about different aspects of the same thing, it may be that they all approach the issue from their respective perspectives, but despite all good intentions, provide potentially competing perspectives without realizing. And so at that point, there'll be work for the lawyer and client to try and resolve those factual differences and then find a way of understanding what the answer is for the relevant issues in dispute. Second, what is the technical nature of the systems? For example, I've not heard anyone say that it is possible to preserve a cloud-based system so that one can see how it was operating at a specific point in time. One may be able to preserve the documents related to the system, such as those on the system, or the logs generated, or ancillary documents such as deployment documents, but it won't be possible to then preserve the system itself. However, large systems are likely to hold and produce significant volumes of data. And so in any event, preserving or collecting that data may be disproportionate relative to the issues in dispute and the overall case. Further, if the system in dispute is one that a party still uses, there's a question about whether it's possible to interfere, for want of a better word, with it for the purposes of litigation whilst the party or parties still require it operationally. My third observation would be that, well, we have to ask where the data is held and who has access to it. Does the party have a right to the data that it needs? Even if it thinks it does, will the relevant entity that holds that data provide it? So we often see in IT disputes that there may be a third party, or indeed multiple third parties involved, who provided a solution or a service. And then there are questions about whether and to what extent that third party becomes involved in the proceedings, and in any event, whether and to what extent its data is available in those proceedings, and then how it's protected as well.
Lots and lots of complicated things to think about. It's sort of almost like carrying out open heart surgery on a live system sometimes, where you've got a system that still has to continue to be in operation. There might be users using it in real time, as well as live litigation going on simultaneously. Now, one of the issues that lawyers can be in control of, generally speaking, are the pleadings itself, and they can be very helpful in identifying the scope of what's relevant to a particular dispute, albeit often with computer systems, there's a large degree of informational asymmetry between the parties. The party with the system knows a lot more about what the system is than the party who just sees what the system produces from their perspective. But what other sorts of things can clients or lawyers do which help make the disclosure exercise more manageable than it would otherwise be in the context of disputes about large computer systems?
So the first point I'd make is that clients will hopefully have access to the right documents and the right people. So the documentation is likely that which was created and used part of the procurement, deployment, and monitoring of the systems. What actually you do need to get access to will depend on the issues in dispute. But from the client's perspective, it will be important for them to understand where that documentation is, what the relevant documentation is, so for example, the latest versions, and also how it can be navigated so that one can then try to get to the answers. But sometimes not everything is captured in documents, so clients may need to provide access to the people with the relevant technical knowledge and experience to help explain what the documents mean and what happened in practice. Of course, that's easier said than done, And it's difficult when there are large teams and multiple parties involved. It's also potentially more complicated when those people still have their day jobs and that they are still trying to deliver the project that's now the subject of the dispute. Second, what lawyers can do is that they can have some technical expertise. That does allow lawyers to then have informed conversations so that when we get information from our clients, we can critically assess it and understand how it fits as part of the bigger picture. And those comments there would apply also for in-house counsel as well, for them having the appropriate technical knowledge in their specific domain. But I do say some technical expertise, as I think we do have to recognise that we're first and foremost lawyers, and some computer systems are so complex that they will require people with significant technical expertise, and it's unlikely that a lawyer will have that. But what we should have from our training experience is the ability to ask the right questions and then the ability to engage with the facts once we receive them. Third, the legal and factual issues in dispute will be key, as you mentioned. And so the lawyers and clients will be central in helping ensure that those legal and factual issues are appropriately defined and that any factual investigations subsequently are then appropriate.
It's interesting, isn't it? And your experience mirrors mine in a certain way, that people sort of assume that these technical disputes about huge computer systems are very much often about the data. And that is a very, very important aspect. But key to resolving them are very often the people. And it's that combination of the technical people who actually understand what the system is doing and what it isn't doing, and where relevant information is either stored or can be seen and observed in a way that it can be proved into court, plus the lawyers working together. I've often found them some of the most interpersonal cases in terms of working together as people when the subject matter is particularly technical. Can you just sort of talk us through how this can actually work in practice when the dispute itself is about the operation of an AI system?
So to turn first to what is the dispute about? And so again, that requires careful factual analysis. So for example, is it about the AI system itself and, as you say, about the operation? Or could it actually be about something else, such as how the AI system was used more broadly as part of the wider organization, as part of wider decision-making systems? And so consequently, maybe more of the focus is about how the outputs were used and what inputs were there and how the humans were then operating with the system. So let's just take a couple of examples. So one could be for breach of a contract, where the customer alleges that they bought an AI system X, but what they received was actually AI system Y. So in that case, it's likely necessary to carefully analyse what was purchased, what was promised, and what was ultimately received, considering the technical aspects of the AI system. But even then, much will turn on the facts and potentially on some expert evidence as well. So, for example, how do you determine whether the system purchased is or is not what was received? One possible way of doing that is by looking at the technical design of the system itself and whether what was promised, what was received. But another potential way would maybe by looking at what the AI system was capable of achieving or what it did actually achieve, and whether that then met the obligations and the objectives that the purchaser had. So in contrast, perhaps the dispute is focused on the outputs of the AI system and whether the party allegedly in breach made decisions appropriately using those outputs and potentially other factors too. Is the focus on how the AI system operated to understand whether there was a rational, reasonable process, for example, and that it operated within the parameters that were expected? Or is the focus instead on how the decision maker exercised their discretion or their decision making by taking into account the AI system outputs and the other factors? So whether the analysis is about the AI system operation or how the organization used the outputs may affect what level of analysis is required of the system itself. That will have a knock-on impact for disclosure, witness evidence, and potentially expert evidence, and many other dynamics within the case too. Also, we've discussed some of the other issues which will be relevant to disputes about AI systems. So, for example, access to relevant documents, access to relevant people, third parties who may hold relevant information but may be protecting their position, and then understanding the technical nature of the systems and then ultimately what's achievable with them. And then what I would say with all of this is that it's very difficult to predict the future. And we've seen the pace at which AI as a technology but also AI use cases have been evolving. So studies have shown how AI systems are improving rapidly, so when compared to human benchmarks, and we're still at relatively early stages of AI adoption and investment. So I would expect resolving issues about AI systems in the future could become more complex. So having the right people involved will be key. And to an extent, clients should be thinking in advance about, do they have the right people? Do they have the right documentation? And what happens if things do go wrong? What will their systems and processes be? And will they be able to respond?
So, having said that it's difficult to predict the future, I'm now going to ask you about the future and ask about, are there any particularly legal developments or technological developments that you think will actually change how disclosure management is done in future?
Yes, there are multiple developments in different areas, all at different stages and in different domains. So let's just pick a few. So first of all, there's a number of government reviews. One such review is for the criminal justice system and looking at the role of computer evidence, how it's treated and how it's used within criminal cases. The second example is that there are reviews in the high courts. So, for example, in the business and property courts, disclosure rules are being reviewed to see if the rules and guidance require updating. And then third, there are potentially new laws. So, for example, there's the Duty of Candour Bill. This duty would establish new obligations on public bodies and officials to help investigations to find the truth, providing information and evidence with candour, proactively and without favouring their own position. This duty will apply to statutory and non-statutory inquiries and coroners' investigations. It applies to the public sector and some private bodies, such as those delivering public functions, and then there are sanctions for those in breach. What I would draw out from these examples is that the role and significance of evidence will remain likely important within all of those, but ultimately it will be different depending on the legal area that we're talking about. Related to that, whilst evidence is important, there are other factors in play within each of those proceedings. So, for example, the speed and the cost of proceedings, the types of parties involved, and the intrinsic value in the process of disclosure itself. And then the further thematic point that I just draw out of all of that is that many parties may find that they are subject to multiple proceedings at the same time, and then subject to multiple sets of disclosure procedural requirements, which may be conflicting or maybe difficult to navigate together, and so that there will be potentially competing and challenging issues that they will have to face in that regard.
Well, indeed, we could do another podcast episode on the potential tactical differences and strategic differences between different types of litigation in the context of the disclosure systems that they operate. And just this week in the United Kingdom, the Law Commission has announced that it's going to review public sector use of AI in automated decisions. And one of the reasons stated for that is because of the issue of disclosure and how the duty of candour works in judicial review proceedings, which is different entirely to the duty of candour bill that's going through Parliament, and how that informational asymmetry works or possibly doesn't work in the context of public sector use of artificial intelligence. So there's certainly lots more new on the horizon. Do you think that the UK is approaching any of these issues differently to other common law legal systems or civil law systems, Tom?
Yes, I think it is. And I think that a lot of the disclosure regimes that we are then looking at ultimately reflect experiences that have been had. So, for example, when it comes to government reviews, with the Duty of Candour Bill is directly the result of a number of high-profile inquiries and seeks to redress a number of the issues that arose from those inquiries. But also the UK is very mindful that there are some parties who are able to look at different jurisdictions. And so the disclosure regime is one of the factors, not the only factor, but one factor which is relevant to parties choosing to litigate in the UK. And that we want to be competitive internationally so that if it's appropriate, parties can litigate here rather than choosing to do so elsewhere. I would like to make the point, though, that often parties can't choose which proceedings they go to. So they may find that they are the potential claimant or applicant, and in which case there's a limited number of routes to redress that they may have access to, so that they have limited choice, if any choice, about which one to go down. Or perhaps the party is the defendant, in which case it may be fixed with a particular type of proceeding due to the nature of the contract, due to the proceedings that's been brought against it, and consequently it will be limited in that regard. And what I'd also then say from all of that is that If a party is looking at different potential systems, then it will also be looking at other factors as well. So, for example, overall trust in the system. So, for example, trust in the judiciary and in the judicial process. And then also other factors like the overall speed of the process and the ability to enforce any judgment or award.
Well, thank you for that. That was all absolutely fascinating. We're now going to sort of pivot to a question that David Mitchell, my co-presenter, and I, we always ask our guests the same question at the end of an episode, and that's a scale question. On a scale of from 0 to 10, with 0 being the most pessimistic and 10 being the most optimistic, how you yourself feel about AI and the role it will play in the future going forwards. And this is your view, not your firm's view, if you're happy to share that with us.
Thank you, I am. So this may reflect the time of day and the time of week and how things are going. But certainly right now, I've gone for a 10. And a lot of that depends on whose future you're talking about. So when I think about it from my perspective as a lawyer using AI tools, I do see that there's a lot of optimism, a lot of opportunities to use AI appropriately and responsibly to deliver better outcomes for our clients and also for our colleagues. And that's because AI provides a series of additional tools that can be directed at some of our key challenges as litigators or as advisors. But I do recognise that many people will have legitimate concerns about AI and the future, and in particular about how and why humans and organisations use AI. So if you had asked me the same question in that context, or in a different context, I'd have probably given a different answer, but we can leave that for another day.
Well, thank you very much, Tom. I think you are the most optimistic of any of our guests on this podcast series, but it's lovely to have a diversity and a breadth of views on the particular topic. Thank you, Tom, so much for coming to talk to me today, and thank you for listening. You've been listening to the 39 Essex AI and the Law podcast. For other episodes, please visit 39essex.com. If you have any thoughts as to any further episodes that you'd like to hear from either David Mitchell or myself, then please do contact Chambers through the addresses on the 39essex.com website. Thank you for listening, and goodbye.